In the heart of Mumbai, where history and justice intertwine, stands an institution older than the nation itself. The Advocates Association of Western India, or AAWI. Founded in 1864, AAWI is the oldest bar association in India. A living testament to the evolution of the Indian legal profession. AAWI began its journey as an association of Wakils on the appellate side of the Bombay High Court. Just 2 years after the court's own inception in 1862, visionaries like Dheeraj Lal Mathuradas, Shantaram Narayan, Rao Sahib Vishwanath Mandlik, Nana Bhai Haridas, Pandurang Balibhadra, and Ganpat Rao Bhaskar laid its foundation, creating a platform for Indian lawyers to find their voice and identity in a colonial legal system. In its earliest days, the original side of the High Court was dominated by European practitioners, while the appellate side bar was entirely Indian. The association soon became a crucible for legal talent, nurturing generations of lawyers who would go on to shape not just the law, but the destiny of the nation. AAWI's legacy is deeply entwined with India's freedom movement. The bar counted among its members giants like Mahatma Gandhi and Sardar Patel. Many of our national leaders were lawyers. Their legal training and advocacy skills fueling the push for liberty, rights, and democracy. The association evolved with the times. Renamed as the Pleaders Association of Western India in 1881, and finally in 1929 as the Advocates Association of Western India, reflecting the changing face of the Indian Bar and the enactment of the Indian Bar Council Act. Till now, AAWI has given India 7 Chief Justices of the Supreme Court. Honorable Chief Justice P.B. Gajendra Gadkar, Honorable Chief Justice J.C. Shah, Honorable Chief Justice Y.V. Chandrachud, Honorable Chief Justice Sharad Arvind Bobde, Honorable Chief Justice Uday Umesh Lalit, Honorable Chief Justice D.Y. Chandrachud, and Honorable Chief Justice B.R. Gavai. The association has always believed in nurturing talent, regardless of gender or background. Today, AAWI stands as a vibrant community, upholding the motto, respect the law and the law protects you. For 161 years, it has championed the rule of law, providing legal aid, advocated for judicial reforms, and fostered excellence and ethics among advocates. As we celebrate 162 years, we honor a legacy built on justice, integrity, and service. The Advocates Association of Western India remains a beacon for the legal fraternity, inspiring generations to defend the rule of law and uphold the ideals of our Constitution. Continuing its grand tradition, AAWI takes pride in commemorating the achievements of Justice B.R. Gavai and felicitating the Honorable Chief Justice of India, Justice Surya Kant, on the occasion of its 162nd Foundation Day. Justice Surya Kant, through his unwavering integrity, dedication, and commitment to justice, has inspired generations of young lawyers. From colonial courts to the digital age, AAWI's journey mirrors the story of modern India, steadfast, progressive, and ever committed to justice. Here's to 162 years of excellence and to a future guided by the enduring spirit of the law.
Very good afternoon to everyone present in the auditorium, the Honorable Chief Justice of India, Honorable Shri Surya Kant sir, the Acting Chief Justice, Shri Ghuge sir, the judges of our court, former judges, the entire registry and the respectable audience of the dais, on the dais. The time has come for which we all were waiting, the keynote address on mediation by the Honorable Chief Justice of India, Justice Shri Surya Kant. Honorable the Chief Justice of India, Justice Shri Surya Kant is amongst us. My Lord has joined virtually. May I request the participants to give a big round of applause to the Honorable Chief Justice of India. We express our deep gratitudes to Honorable the Chief Justice of India, Justice Shri Surya Kant, for his kind gesture, sparing time, accepting to deliver the keynote for today's intensive workshop. The association wished to offer a floral bouquet to the Honorable Chief Justice of India, Justice Shri Surya Kant. May I request Honorable Justice Bharti Dangre Madam to accept the floral bouquet on his behalf. Being a representative, may I now request our President, Shri Prashant Relekar sir, to give the floral bouquet for the Honorable Chief Justice of India to be accepted by Justice Bharti Dangre Madam. Thank you very much, Madam, for accepting our floral bouquet on behalf of Chief Justice of India, Justice Surya Kant sir. May I now request our President, Shri Prashant Relekar sir, to give his opening remarks.
Good afternoon, everybody. Honorable Justice Bharti Dangre Madam, Honorable Justice Sandeep Marane, Solicitor General Anil Singh, Gautam Mehta, and all who are sitting off the dais, on the dais. When we planned this workshop, our aim was to bring together experienced members from the bar and bench and create a meaningful learning opportunity for the legal fraternity, especially young lawyers. Over past 2 days, we have seen exceptional session with great legal minds giving us an enriching insight on each topic, enhancing our wisdom in arbitration and mediation. Everything right from topic selections designing of diary, compilation and publication of book given to you all in a welcome kit has been the result of tireless efforts of this team. Our greatest support has been the enthusiastic participation we received from the lawyers, not only across Mumbai, but the entire Maharashtra. We have people from Chhatrapati Shivaji, Sambhajinagar, Pune, Nagpur, Nasik, and many other places. The second backbone is the research and volunteer team. All have worked tirelessly for many days and played a key role in making this event a grand success. I cannot miss acknowledging a drive force behind this initiative, Advocate Tejas Dande and Advocate Priyanka Bansali, whose constant encouragement has been an inspiration and most of all invaluable. While this workshop marks another step in AAWI continuing commitment to legal education and professional excellence, we are pleased to share that our next academic initiative will focus on artificial intelligence and its impact on law, justice, and legal practice. All of this is further encouraged by the firm support and we continue to receive from the bench. We are also thankful to the Chief Justice of India, Shri Surya Kant, whose participation added a great dignity in this initiative. He will be coming right now on the VC. We are the gracious presence of Honorable Chief Justice of India, Shri Surya Kant, Honorable Acting Chief Justice of Bombay High Court, Ravindra Guge, Justice Ajay Gadkari is a testament to that support and makes this event truly memorable. I hope that the discussion we had over these 2 days will continue beyond the auditorium and contribute in some measure to enhance the culture and arbitration and mediation of our country. Thank you.
Thank you, the President, sir. Since the Honorable Chief Justice of India, the Honorable Surya Kant sir is present, may I now request the participants to give a big round of applause for the Honorable Chief Justice of India, Shri Surya Kant sir. Being a valedictory function, it is our duty to give a brief summary of what transpired since yesterday in the workshop and the takeaways of the workshop. We consider it as our duty to update the Honorable Chief Justice of India, Justice Shri Surya Kant sir. My lords, in these 2 days, the workshop which was going on, there were 7 sessions conducted by 7 honorable judges of the Bombay High Court, 7 senior advocates, 1 district judge who is a trainer from Supreme Court Mediation and Conciliation Project Committee, and 1 senior accredited mediator. I must also inform that there were 600 registrations for the workshop, and the participants have traveled from all over Maharashtra, from places such as Aurangabad, Kolhapur, Pune, Nasik, and etc. I must also acknowledge that this workshop got full support from the Arbitration Committee of Indian Merchant Chambers and its chairman, Shri Gautam Mehta, and also the vice chairman. The workshop was inaugurated by our acting Chief Justice, Shri Ravindra Vittalrao Guge sir, and the Honorable Justice, Shri Ajay S. Gadkari. Honorable Acting Chief Justice, in his inaugural remarks, gave a very detailed comment on the arbitration and mediation. His remarks gave a full idea about the topic and workshop to our participants. Acting Chief Justice Shri Ravindra Guge sir also discussed various challenges in making the ADR process successful. Honorable Acting Chief Justice also highlighted need of capacity building of the bar. Justice Ajay Gadkari highlighted need of proactive role to be played by advocates to make alternate dispute resolution successful. My lords, in session 1, the topic was arbitration law in India, taking stock and assessing impact. Justice Suman Sham, who was our constant support during arranging this workshop, very lucidly explained the key features of law, its base taken from Unilateral Model Law 1985 and New York Convention 1958, Geneva Convention. The panel also discussed on enforcement of foreign awards and also highlighted the goal to make India a hub for arbitration. Minimal court intervention, maximum party autonomy were also discussed in this session. Senior Advocate and Additional Solicitor General Shri Anil Singh complemented the session with his analytical skills and various landmark judgments, key principles such as party autonomy, competence, and etc. My lord, the session number 2 was on the topic of Section 8 and Section 16, interplay and relevance. The panel was consisting of Honorable Justice Shri Somasekhar Sundaresan and Senior Advocate Shri Vineet Naik. I must mention here that the entire topics and the format of the present workshop was designed under the guidance of Justice Somasekhar Sundaresan. The topic for this second session was interplay between Section 8 and 16. The panel elaborated objects and scheme of these provisions, minimum judicial intervention, limited prima facie inquiry at the referral stage, the doctrine of competence, and the doctrine of separability was also touched by the panel. Senior Advocate Shri Vineet Naik took pains to elaborately explain intricacies of the said provisions. My lord, the third session was conducted by Honorable Justice Shri G.S. Kulkarni and Senior Advocate Shri Atul Damle. The topics covered in the said session was in respect of Section 34 and 37. Justice Shri G.S. Kulkarni simplified the said topic in such a manner that the attendees realized what would be the limited scope and grounds for challenge under Section 34 and 37. The session was complemented with comments by Senior Advocate Shri Atul Damle. His elaborations on Section 37 were indeed enlightening. My lord, the session 4 was conducted by Honorable Justice Shri Riyaz Chagla, Honorable Justice Shri Farhan Dubash, and Senior Advocate Shri Vishwajit Sawant sir. This session was on all the practical aspects of the arbitration. The panel elaborated from the stage of studying the brief for arbitration till passing of the final award. The panel also explained what cautions lawyer has to take while conducting the arbitration. The panel also harped upon switching to the advanced digital mode of transcription. My lord, the session number 5 was conducted by Honorable Justice Shri Manish Pitale and Senior Advocate Shri Nitin Thakkar. The topic covered in session 5 was about the interim protection and the parameters applicable under Section 9, 17, and 37 of the Act. The panel unfolded the ingredients of these sections and presented a crisp note for lawyers while handling arbitrations at interim protection stage. The highlight of this session was updated and latest case laws given by the panel. With these 5 sessions, the day 1 of the workshop got concluded. My lords, on the second day of the workshop, that is since today morning, the session 6 discussed on the topic of mediation, an underutilized means of dispute resolution. The panel for session 6 was an apt combination of a judge of Bombay High Court who sincerely wished to eliminate all the hurdles in making mediation successful. Justice Bharti Dangre, who is genuinely worried about the slow pace of mediation process, guided the attendees on the positivity to be inculcated amongst the members of the bar. The practical aspects were elaborated by District Judge Shri Kishore Jaiswal, who happens to be trainer from Supreme Court Mediation and Conciliation Project Committee. The session was also complemented by Ms. Tanu Mehta, who is an accredited mediator and is a known personality for delivering results while working as a mediator. The last and seventh session was conducted by Justice Sandeep Marne and the most eminent senior advocate, Shri Girish Godbole. The panel covered all the statutory provisions and the noble object behind mediation. Senior advocate Shri Godbole, who has demonstrated a highest degree of loyalty to law profession and mediation, highlighted the need to put in sincere efforts by members of the bar to make this entire exercise successful. Mr. Godbole also highlighted concept of community mediation. With these 7 sessions, the workshop gave a very detailed insight of the topics to the attendees. My lords, Honorable Chief Justice of India, now the entire house, the entire auditorium is waiting for your lordship's keynote address on mediation. May I now request Honorable the Chief Justice of India, Shri Surya Kant sir, to deliver his keynote address.
A very good afternoon to all of you. My sincere apology that I wanted to be along with you, physically present in this event, but for my some urgent administrative meetings which I had to hold yesterday and today again that I could not make it. Therefore, I sought your permission to join you online. And thank you very much for inviting me, and thank you very much for giving this opportunity to share my views along with all of you. I believe Justice Ravindra Bhuge also could not join the learned acting Chief Justice is down with virus, but in his absentia, Justice Bhuge, Justice Ajay Valedictory, Senior Judge of the Bombay High Court, my distinguished brother and sister judges of the Bombay High Court, Dr. Milind Sakhe, learned Advocate General for the state of Maharashtra, Shri Anil Singh, learned Additional Solicitor General for Bombay High Court, Shri Prashant Relekar, President of the Association, Advocates Association of Western India, the real dynamic bar, which has taken up one after the other very the pragmatic issues which require attention of the members of the bar, and I am so happy, and on a personal note, I must congratulate the Advocates Association of Western India for taking so much keen interest in the academic and constructive activities. My congratulations to Mr. Suresh Sarbat, Secretary of the Association, other esteemed office members of the Advocates Association of Western India, distinguished senior advocates of the bar, legal professionals, learned arbitrators and mediators, other stakeholders, ladies and gentlemen, friends from media. It gives me immense pleasure to address this august gathering at the culmination of an admirably conceived and meticulously curated workshop hosted by the Advocates Association of Western India. Few institutions can claim the vintage this association carries as 160 years is no small inheritance. For an association that has watched legal practice migrate from quill to keyboard and from the colonial code to the constitutional code, to how fluency in arbitration and mediation is not merely fitting. It is entirely in consonance with its character. As I said, dear friends, that I could not come personally, but I immediately reflect the Nariman point, and to my mind, it is a befitting destination for this conclave, as that is the point where the RBNC once ran freely, cartload by cartload, rubble and debris were carried here and laid against the tide through storm and setback, until slowly the sea yielded and dry land emerged where once there was only water. I also find this occasion to cite an old Marathi saying that captures this labor precisely. Theme theme tale sache, drop by drop, the lake is filled. The message is simple. Lasting work is done steadily, not through one grand gesture. I bring up Nariman point and Marathi wisdom because I do believe that over these 2 days, all of you have been engaged in a reclamation of your own. You have been, session by session, reclaiming a space for dialogue within a profession that has long prized only the space for contest and adversity. You are regaining the wisdom of our forefathers who preferred conciliation over litigation, and you are rebuilding a tradition older than any written statute. This kind of work, my dear members of the bar, deserve more than our applause alone, it deserves our candor. And in the spirit of that honesty, I will not use today's ceremony to rehearse the familiar virtues of alternative dispute resolution. After 2 days of sustained engagement with arbitration and mediation, I am sure this distinguished audience has little need of another general endorsement. Instead, I want to use this valedictory hour differently to speak about the principal challenges that will determine whether mediation evolves from being a statutory alternative to the backward mode of dispute resolution by Indians. So I take it that this momentum is not yet a culture. And first of all, I invite you all to consider what this movement already holds. In India, mediation is no longer viewed as a last attempt at compromise after litigation has failed. Parties are across the country increasingly willing to enter mediation. Lawyers are more prepared to recommend it, and the courts and institutions are making it a regular part of dispute resolution. That wider acceptance is also reflected in the scale of our present initiative. For example, Mediation Coordination 2.0 is presently working through 2.33 crore pending cases across our taluka, districts and high courts, building on a first drive that in 90 days saw over 1 lakh cases settled out of 5 lakh records. Later this month, the historic Samahan Smaho will culminate in a special Lok on 21st to 23rd of August, where all 34 of my learned colleagues will sit to hear matters identified for settlement. I solely believe that the momentum of this kind must be protected, tested, and prepared for what lies ahead, or it is as quickly as it gathers. That is why, having worked closely with mediation across all echelons of our vast judicial system for 4 decades now, I want to spend the remainder of my time not celebrating this report further, but on deliberating 3 challenges that we must seriously address so that mediation in India is as formally opted for as conventional litigation. So what are those 3 challenges, my dear friends? I personally believe, and I have crafted them as trust, threshold, and technology. So according to the first challenge of trust, the most fundamental challenge is trust. The principal difference difference between adjudication and mediation, in my opinion, is that while the former can operate through authority, the latter cannot. And trust in mediation begins only when each party believes that the room is safe, the mediator is impartial, the process is confidential, and the other side is present in good faith. Without that crucial confidence, instead of disclosing interests, parties will simply repeat their pleadings in a smaller room. So we must ask ourselves, how do we build and nurture trust between two litigating parties? I believe part of the answer lies in traditions that our own soil already knows. I have said this before, including yesterday only at the Commonwealth Peace Mediation Conference in Jaipur, that the instinct to conciliate is not alien to Indians. It is our ancestral asset and the values that we have inherited from generation to generation. It runs all the way from the time of Ramayana to Mahabharata, where Lord Krishna, who stood as mediator between two warring sides before the Kurukshetra war became inevitable. You have thereafter Kautilya's Arthashastra prescribed four instruments of statecraft. He says, Sam, Dan, Ved, and Dan. Now, out of the Sam is conciliation and mediation. So, even out of the four options which Arthashastra prescribed, the first option was mediation and conciliation. Thereafter, it is the regular court and followed by impeachment and all events will take place. So, mediation has been in our culture, in our tradition, in our values, as the most preferred mode of adjudication of disputes. Our classical legal texts go further still. The Smritis of Yajurveda, Brihaspati, recognize tribunals as the Kula, the Shreni and the Kuga, family councils, trade fights, and local assemblies that settled disputes long before a matter ever reached the king's court. Mediation, then, is not a foreign import drafted into our legal system. It is closer to our default setting, with adjudication historically the exception and not the rule. But we must recover it in a way which is workable for the modern age. The old panchayat builds legitimacy from proximity, as everyone in the village knew the elder and consequently respected them. A modern mediator cannot rely upon that familiarity, and so he or she must earn legitimacy through integrity, and trust follows integrity, as surely as the day follows the light. The second challenge to my mind is the threshold. This I call the gap between entering mediation and actually taking part in it. In courtrooms, judges loathe to see the office report that clearly states mediation has failed between the parties. But that one line is proof that although a court order may bring parties into a mediation room, it cannot force them to negotiate honestly. So we need to earnestly move away from more compelled attendance to genuine participation. In that spirit, early reference is very valuable, as it does not leave room for pleadings and repeated hearings to harden disagreement into implacability. At the same time, the judge who refers a matter to mediation must do so after some consideration and internal satisfaction, not as a matter of routine or to clear the court's doctrine. Another way of encouraging genuine participation is training the qualified mediators who can manage anger without becoming defensive and convert an ego clash into a nuanced and lasting settlement. That ability comes from serious training, realistic simulations, and experience. I have been told that we need more than 2.5 lakh trained mediators in our country. That mark we have not been able to achieve, though the Supreme Court Mediation and Conciliation Committee is regularly imparting training online or otherwise. But I can assure you that we are working on it, and very soon we will be able to provide adequate trained mediators to the extent they are required to tackle the expected cases which are likely to be recorded in due course of time for mediation. The third important challenge, my dear friends, is technology. Finally, this third challenge comes from technology. I have already seen how online mediation reduces distance, cost, and delay. I have also noticed how digital tools can enable a migrant worker, an elderly litigant, or a smaller business owner to participate without traveling across the state or losing a day's livelihood. Yet, convenience has never been a guarantor of holistic justice. Artificial intelligence may organize documents, translate language, summarize positions, and identify apparent convergence. But an algorithm cannot reliably understand whether a pause reflects fear, grief, agitation, or calculation. Nor can it bear moral responsibility for a settlement's fairness. This is precisely why technology must remain assistive, never substitute. We must allow the digital age to carry mediation beyond metropolitan centers, and at the same time ensure that it does not leave citizens technically connected but practically unheard. The future we should seek is not mediation without mediators, but mediation in which technology removes distance while human judgment remains responsible for justice. Let me now return to the candor I promised at the start. I chose to spend this valedictory hour on trust, threshold, and technology because, in my opinion, all three converge upon one figure, namely the bar. This is why the bar must be the vanguard of the mediation movement. The same skill once used to win a dispute must now also be used where appropriate to end such dispute. And thankfully, I have recently observed a large increase in number of legal practitioners who are beginning to understand that mediation does not diminish the advocate's craft, it enlarges it. Dear friends, the real work of this workshop begins tomorrow. When you return to court or to chambers, identify one matter in which the parties have more to preserve than to prove. Ask not only who is legally right, ask also what will remain when this case is over. Will the siblings will still share a home? Will the shareholders still run a company? Will a public project resume? Once you answer those questions honestly, your practice and poise will earn a distinction no designation can confer. We often say that justice must not mirror society's anger. It must model society's reason. Mediation is the most practical way to model that reason because it asks citizens to do the hardest democratic work, namely to listen, to recognize the other's humanity, and to craft a solution that can both live with. May this workshop only serve to strengthen that culture. May the Advocates Association of West India carry this work even onward, mending the fibers of trust and planting the seeds of lasting peace. The future of mediation rests not in statutes alone, but in your hands, your counsel, and your advocacy for dialogue, reconciliation, and fellowship. In doing so, you will shape a future where the legacy of justice is not only written in the judgments pronounced, but also felt in the enduring ties of family, friendship, and community. My special thanks to every member, every office bearer of the Advocates Association of Western India. I also thanks and
Thank you very much, my Lord, the Honorable Chief Justice of India, for the valuable inputs on the topic. The takeaway, first is the trust, dialogue, assurances on training given by the Honorable Chief Justice of India. Most importantly, the use of technology in the mediations. Lord, we are extremely grateful for your Lordship's guidance and keynote address. The association would also wish to acknowledge in respect of session 6, in which our most senior member and considered as one of the most result-oriented mediator at the appellate side of the bar, Shri S.G. Deshmukh sir, his notings and his messages given in the session 6 would also be inspiring. May I now request our secretary to deliver the vote of thanks.
Honorable Chief Justice of India, Honorable Justice Shri Surya Kant, Honorable Acting Chief Justice Shri Ravindra Vittal Rao Goge, Honorable Justice Ajay Gadkari, Honorable Justice Bharti Dangre, Honorable Justice Sandeep Marre, Honorable Justice of the Bombay High Court, distinguished dignitaries on the dais and off the dais. It is my great privilege on behalf of the Advocates Association of Western India to propose this vote of thanks. The workshop has been a wonderful learning experience for all of us. Over the last 2 days, we have gained valuable knowledge on arbitration and mediation from some of the finest minds in the legal profession. Our heartfelt gratitude goes to the Honorable the Chief Justice of India, Justice Surya Kant, for sparing his valuable time and inspiring with us his thoughts on mediation. Thank you so much, sir. We are also grateful to Honorable Acting Chief Justice Shri Ravindra Vittal Rao Goge and Honorable Justice Ajay Gadkari for encouraging this initiative and supporting the association. We are indeed grateful to Honorable Acting Chief Justice Goge sir for attending the inaugural function and this validity function in spite of not being well, though virtually. Thank you so much, sir. We are thankful to Honorable Justice Ajay Gadkari for attending the inaugural function. Thank you so much, sir. We are thankful to Honorable Justice Bharti Dangre and Honorable Justice Sandeep Marne for graciously attending the validity function. Thank you so much. I sincerely thank Honorable Justice Girish Kulkarni, Honorable Justice Suman Shah, Honorable Justice Som Shekhar Sundaresan, Honorable Justice Riyaz Chagla, Honorable Justice Farhan Dubas, Honorable Justice Manesh Pitre, Honorable Justice Bharti Dangre, and Honorable Justice Sandeep Marne for chairing various sessions. Despite your professional commitment, you took out time, rearranged your schedule, and shared your valuable knowledge with us. Your guidance has made this workshop meaningful and benefit lawyers of every generation. Thank you so much. A special word of gratitude also due to distinguished speakers, Honorable ASG Anil Singh sir, Senior Advocates Vinit Naik, Atul Damle, Vishwajit Sawant, Nitin Thakkar, S.G. Deshmukh, Kishore Jaiswal, and Tanu Mehta. Thank you so much for sharing your time, experience, and deep insights. Your practical perspectives have greatly enriched this workshop and have left us with learnings that we all carry forward in our professional lives. We are also thankful to respected ASG Anil Singh and Shri Gautam Mehta, Chairman of IMC. I also extend my sincere thanks to the High Court Registry for their constant support and ensuring every session was conducted smoothly. One more special mention is required for our member, Shri Tejas Dande. This workshop on arbitration and mediation could be successful only because of his tireless efforts and planning. Indeed, the workshop is a big success. Special thanks to the project coordinator, Ms. Pinky Bansali. Your hard work made this event a grand success without any difficulty. The association would be indebted and grateful to both of you. Our appreciation also goes to the design team for creating the beautiful theme of this workshop and to the brochure team led by Mr. Sarvesh Todkar for preparing such an excellent brochure within a short span of time. A big thank you to our registration team, backstage team, volunteers, technical staff, photographers, hospital team, and every member of the organizing committee. Lastly, I thank all the participants for your enthusiastic presence and active participation. Your interest and involvement made this workshop truly grateful. On behalf of the Advocates Association of Western India, I express my sincere gratitude to everyone who contributed directly or indirectly to the success of this workshop. Thank you so much.
Thank you, Mr. Sabrat. Before we conclude the valedictory session, there is a message to everyone that the lunch would be served after the conclusion of the valedictory function. May I now request everyone to stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय जय जय